For our next story, we're going to cover a story of an attorney who was disciplined by being disbarred. Now, what makes this case interesting is that the attorney wanted to be disbarred. He wanted to be disbarred. He asked to be disbarred. And so this court decision is analyzing a request to be disbarred. And the court seems to struggle with this because they don't have any case law, because, of course, this is not a thing that happens. But it did happen. So we're going to read the case of Glenn Stevens and him being disbarred because he wants to be disbarred. So that's a thing that happened, and we're going to read it. In this extraordinary manner, disciplinary counsel seeks to have respondent disbarred. Respondent has also unequivocally and colorfully sought to be disbarred. In this unique posture, we must determine where the disciplinary system should expend substantial resources on the merits of a case that each party would like to have end in disbarment. For the reasons set out below, we conclude respondent should be disbarred without an analysis of the merits of the case, and we recommend that the Court of Appeals grant respondent's clear request that he should be disbarred. This matter involves 4 separate disciplinary complaints against the respondent. Respondent was personally served with the specification of charges, but he did not proceed in any hearing, either in person or through counsel. He did not file an answer, nor did he file any other pre-hearing documents. He did not appear at the hearing, nor did respondent file a post-hearing brief with the hearing committee. Rather than participate in these hearings, on March 1, 2018, respondent sent an email to Deputy Disciplinary Counsel Julia L. Proctor. The email subject was, "Maybe I wasn't clear, ... and its content requested the disciplinary counsel disbar. Please don't kill trees, waste taxpayer resources, and Office of Disciplinary Counsel personnel on me. The Office of Disciplinary Counsel has no credibility or legitimacy to me, or the drivel that you create. You are simply dishonest lawyers who do nothing to regulate dishonest lawyers, and racist to boot. Rather than wasting time, money, and paper on your sophistries, please disbar me. Disbarment by the Office of Disciplinary Counsel would be an honor. To date, aside from completing in its triathlon world competition, my greatest honors are a PhD from UCLA and my law degree from Bolat. But a disbarment letter from the Office of Disciplinary Counsel will be framed and go right up alongside these diplomas. Please do the honor of disbarring me. I'll be so very, very proud." Okay. Carrying on. Wow. Just wow. I don't know how to process this completely, to be honest, guys. This is a thing that's happening somehow. After disciplinary counsel put on evidence after a 4-day hearing, an ad hoc hearing committee painstakingly analyzed each of the allegations against respondent and issued a 252-page report concluding that, in representing himself and various clients in litigations and related proceedings, respondent abused the judicial system and ignored ethical boundaries of adversarial advocacy that are key components. The hearing committee determined that respondent violated Rule 3.1, frivolous claims in 4 matters, Rule 3.2a, expediting litigation in 1 matter, Rule 3.4c, violating the rules of the tribunal in 1 matter, Rule 4.2, communicating with a represented person in 1 matter, Rule 4.4a, embarrassing and burdening third parties in 4 matters, Rule 8.4d, serious interference with the administration of justice in 3 matters, and Rule 8.4g, misuse of criminal and disciplinary charges in 2 matters. The hearing committee recommended that respondent be suspended for 3 years with fitness. Disciplinary counsel takes exception only to the recommendation that respondent be suspended for 3 years, arguing instead that he should be disbarred. Oh, okay. So just in case you're having trouble keeping track, they found that he violated a whole bunch of rules, and they recommended that he be suspended for 3 years. And the guy said, "I object to that because I should be disbarred." That is the legal posture at which we are. The Bar Association wanted to suspend him for 3 years, and he objected, saying, "I shouldn't be suspended for 3 years. I should be disbarred." That is the legal posture. Wow. Respondent has not taken exception to the hearing committee report or the hearing committee recommendation. Respondent's email to disciplinary counsel indicates his desire to be disbarred. However, once a disciplinary investigation is done, respondent cannot simply turn his law license back to the Court of Appeals. Instead, the rules set forth the conditions under which a respondent may consent to disbarment while investigation is pending or after formal charges have been filed. The rule requires that respondent submit in an affidavit that the consent is freely and voluntarily rendered, that the attorney is not being subject to coercion or duress, and the attorney is fully aware of the implications of consenting to disbarment. The attorney is aware that there is currently pending an investigation into a proceeding involving allegations of misconduct, nature of which specifies set forth in the affidavit. The attorney acknowledges material facts upon the allegations of misconduct and the attorney submits to the consent because the attorney knows if disciplinary proceedings based on alleged misconduct were caught, the attorney could not successfully defend them. Upon filing of the conforming affidavit with the board would then recommend to the court to disbar. Because the respondent's email indicates a desire to be disbarred but did not meet the requirements for consent disbarment, we issued a show cause order that set out the conditions under which a respondent may consent to be disbarred, including statements that must be obtained in a required affidavit, and we ordered that no later than August 1st, 2019, respondent shall show cause why the board should not recommend to the Court of Appeals that respondent be disbarred forthwith based on consent to be disbarred without further proceedings. The person who is being disbarred responded to the order to show cause, arguing that respondent should not be disbarred on the merits and not on the basis of the email alone. Counsel argued that hearings findings which the respondent has not opposed should be presented to the court as further basis of disbarment. Disciplinary counsel makes two additional arguments against disbarring the respondent on the basis of the statements in his email. First, disciplinary counsel argues that the misconduct following the rule of the hearing will be considered unadjudicated misconduct under Rule 9.8 if respondent seeks reinstatement in the future. Second, the court's disbarment order might not be sufficient for imposition of reciprocal discipline against respondent in the Court of Appeals for the District of Columbia and the United States District Court for the District of Columbia. Respondent did not respond to the order to show cause. Who was surprised by the fact that he did not respond to the order to show cause? No one in the room is surprised by that. Carrying on. Instead, he sent a mailing to the Office of Disciplinary Counsel. In the mailing, he enclosed a number of copies of a color image of Flavor Flav from the hip-hop group Public Enemy with the text ODC is a joke in all caps at the top of the page, in which one can only assume was a reference to Public Enemy's 1990 song 911 as a joke. Okay. Respondent also iterated his prior allegations that members of the Office of Disciplinary Counsel are unethical and racist. Wow. Pursuant to D.C. Bar Rule 11, the board is required to review the hearing committee record and prepare a report of the findings and recommendation, which is then filed with the court. Our review of the hearing committee's consideration of each alleged rule violation would no doubt be a lengthy process, given the extent of the misconduct found by the hearing committee. The board takes seriously its obligation to review the reports and is no stranger to the thorough review of lengthy records, even in those cases which the respondent did not participate. However, the facts in this case are wholly unique, and our rules do not contemplate the situation prepared by these facts. Respondent has indicated his intent to be disbarred. To be sure, he enjoys a number of procedural protections by virtue of the rules. When this board issued a show cause order, we gave respondent an opportunity to avail himself of those protections. Instead, he chose to ignore our order and mailed in a photo of Flavor Flav. We share respondent's concern about spending resources on a case where both respondent and the disciplinary counsel want the same thing, the disbarment. Where a respondent has indicated he does not want protections provided by the rules, we see nothing to be gained by an exhaustive march through these procedures. Accordingly, in light of respondent's unambiguous expression that he seeks to be disbarred and the response to the show cause order, we conclude his response is the functional equivalent of meeting the rule. There is no evidence that respondent's email was a rash, unthinking act. Charges were pending against respondent for approximately 11 months before he requested to be disbarred. He has not repudiated the request, even though disciplinary counsel used it to support arguments of the hearing committee and the board in support of disbarment. He did not repudiate it when ordered to show cause why he should not be disbarred on consent. In short, nothing on the record suggests that respondent's disbarment request was unknowing or improvidently made, or he thought better of it and would like to remain a member of the bar. We recognize the severity of this recommendation, however. Respondent has clearly and unequivocally requested his own disbarment and has not withdrawn that request despite several opportunities to do so, and we consider the additional time and effort for the board and the court to review 252 pages of factual findings and legal conclusions of the hearing committee report in this case will certainly delay the resolution of other disciplinary matters. We therefore see no point in further diverting the disciplinary system's resources away from cases involving respondents who retain desire to seek a privilege of practicing law in the District of Columbia or the public that awaits resolution of those proceedings. Even though it seeks the same result as respondent and this recommendation, disciplinary counsel argues this result should be reached through a different route, the creation of a waiver doctrine. Then would that be applied to the conduct? The counsel argues our approach in the show cause order in this recommendation is flawed. The respondent's action should not be seen as the equivalent of being the rules. Disciplinary counsel identifies potential undesirable consequences from recommending the respondent be disbarred without a finding on the merits. As a general matter, because each of the consequences would be present if respondent had consented to disbarment by the following the literal requirements of the rule, we conclude that accepting these consequences is acceptable and consistent with the rules that govern our disciplinary system. We address each of disciplinary counsel's arguments as follows. Further, disciplinary counsel argues we should use respondent's case as a vehicle to create a doctrine that would allow us to conclude a respondent has waived arguments if they're not made at a hearing committee level. If we were to do so, then, as disciplinary counsel suggests, we could adopt the report without substantive review. The board is sympathetic to this argument. Limiting the board's substantive review of the hearing committee's matters to one or both parties' note exceptions, which is to say formalized objections, would reduce the amount of time necessary to resolve disciplinary cases. However, the Court of Appeals has not adopted a waiver doctrine of this kind, and disciplinary counsel advocates here, and we do not think it's consistent with the rules that govern our proceedings. The C-Bar Rule 11, Part 9b, provides that if no exceptions are filed, which again, exceptions is a word for formalized objections, are filed to the hearing committee report, the board shall decide on the basis of the hearing committee record. The board decision must be based on an actual review of the record, not an unquestioning adoption of the findings. Where the board must accept the hearing's findings is those findings are supported by substantial evidence when viewed as a whole. We cannot determine whether substantial evidence supports the findings without actually reviewing the record. Similarly, because the board's recommendation sanction cannot foster a tendency towards inconsistent depositions or dispositions for comparable conduct or otherwise warranted, a comprehensive fact-based inquiry comparable analysis is required. Given these requirements, we're unable to and unwilling to create a waiver doctrine of the kind defense counsel seeks absent clear direction from the Court of Appeals. Moreover, using this case as a vehicle to create a new waiver doctrine would be a bold expansion of the law. We conclude that a more moderate course of action would be to construe the conduct as a functional equivalent of the compliance with the rules. Defense counsel argues that unless the board and the court fully consider the defense counsel's findings and recommendation, the misconduct under which the hearing committee will have considered unadjudicated misconduct under the rules, thereby placing an evidentiary burden on defense counsel if respondent seeks reinstatement in the future. Again, respondent could simply acknowledge any one of the disciplinary charges against him in an affidavit consenting to disbarment, and disciplinary counsel would be in the same position. Treating the respondent's conduct as unique in this case as satisfying the requirements for consent disbarment does not put the defense counsel in a meaningfully worse position with unadjudicated conduct than consent disbarment would. Defense counsel notes its concern that disbarring the respondent based solely on statements in the email without any admission or finding of wrongdoing could prevent the imposition of reciprocal discipline in the D.C. Court and D.C. Court of Appeals. Disciplinary counsel cites no authority for this concern, and in any event, undertaking extensive review of the alleged misconduct here for the sole purpose of possibly facilitating reciprocal discipline in another court is not sufficient cause to divert the court's resources and contribute to the delay of other cases in the system. Upon consideration of the foregoing, it appears respondent has not attempted to show cause of why he should be disbarred on consent, and defense counsel has failed to show why respondent should not be disbarred on consent. We recommend that the court enter an order disbarring respondent on consent forthwith and without further consideration of the evidence in this case. And perhaps somewhat surprisingly, there were actually dissents to this decision, so I guess there are some real sticklers out there for formalized rules. So there were dissents even to this. So I guess I take some comfort in knowing that there are some people who will really stick to the rules. There's some real proceduralists out there, so I guess I'm comforted by that. Turning to the dissent says, we cannot agree with the majority's conclusion that respondents should be disbarred when the requirements for consent to disbarment have not been satisfied, and the rules do not allow the board discretion to infer consent from circumstances such as those presented here. As the majority describes, the rules set forth a procedure to be followed when a lawyer under discipline investigation decides to consent to disbarment. Because they have not followed the procedure, we conclude the board must carry out its duty under the rules to review the findings and recommendation of the committee submitted to the board and to prepare and forward its own findings and recommendations to the court. The majority has chosen not to review the hearing committee finding and recommendation because respondent emailed disciplinary counsel asking it to be disbarred and failed to respond to board's orders showing why he should not be disbarred. Respondent's conduct is regrettable, but it's not sufficient reason to set aside the procedure by which a member of the bar may consent to disbarment, and in any event the board is not granted discretion to do so. The majority candidly acknowledges that the respondent has not complied with the rules. Notably, deficiencies are not technical or trivial. Most importantly, the respondent has not submitted an affidavit declaring his consent to disbarment, which is required by the rules. Even if respondent's email were construed as an affidavit, which it's not, its content only partially satisfies the rules of the requirement. The email asserts that he wants to be disbarred, and given the clarity of the statement and his failure to recant, we can safely find that he's made the statements freely and voluntarily, and as a result of coercion to arrest, two of the statements that must be included in the consent to disbarment affidavit. Because the respondent set the email issue in connection with the pending matter, we can also find respondent is aware there's a proceeding involving allegations that he's engaged in misconduct. However, the email does not satisfy the remainder of the rule. Nothing in the record permits finding the respondent is fully aware of the implications of consenting to disbarment. Similarly, we cannot find that a respondent is aware of the nature of the proceedings against him. Respondent has not acknowledged the material facts against which the allegations of misconduct are predicated as true, or is consenting to disbarment because he knows he cannot successfully defend against the misconduct. All these are missing facts are required components of an affidavit in support of a lawyer's request to be disbarred. Respondent's email and the failure to respond to the board's show cause order are inexplicable. However, they do not provide sufficient basis for the board to avoid its duty to recommend the findings or review the recommendations and findings. That such review may be arduous undertaking given the voluminous case record is not a reason for the board to avoid its obligations. For the reasons stated above, we dissent from the board's decision to decline to provide the court with a review of recommendation based on the board's review of the committee. Well, that is the story of an attorney who wants to be disbarred and the story of Flavor Flav, which somehow is relevant to this case for some reason. But yeah, that's a thing that happened, so I guess I wish him well on his request to be disbarred, so good luck with that, I suppose. Okay, I got nothing, guys. This one's a weird one.